All right, Jonathan. Thank you for joining us today. We're on an episode of Ivory GC, General Counsel at Unified Patents, Jonathan Stroud. Thanks for being here.
It's nice to meet you too, and thanks for having me. Very much appreciated.
So, Jonathan, tell us a little bit about your background. Kind of what got you into law, and then we'll go from there.
Sure. So, I'd used to say we all lead many lives, and I definitely didn't have a straight path to this position. I wanted to be a scientist because I was rebelling against my journalism family. My father, my uncle, and my brother are all journalists. And so I went to engineering school in New Orleans and had a lot of fun in college and really enjoyed it, but really didn't enjoy the time in the lab. I didn't get enough time reading, and I didn't get enough time speaking and doing the things that I love to do. So, and when I was in college, my father passed away, and that made me take a hard look at what I wanted to do. And I ended up going to journalism grad school at USC for a couple of years and really enjoyed my time there too. I had some amazing internships, did a little travel overseas in South Africa. But while I was in journalism grad school, my brother, who's a successful editor, was not making that much money, and the economic downturn happened, and he lost his house. And I had to sort of take a very sober look at what my life would look like if I dedicated myself to being a print journalist in the modern era, and the prospects were not good. So I took another look at what I wanted to do, and I applied for a whole bunch of jobs with my sort of interesting background, and some papers, and the FDA and the PTO, and some sales jobs offered themselves. But I ended up taking a position at the Patent Trademark Office as a patent clerk. Albert Einstein was a patent clerk, and it had the best benefits, and it was the most interesting job that presented itself. And it was in DC, which is where I wanted to be. But just like with Albert Einstein, I'm sure it was so boring that I needed to do something else with my mind after a few years. I enjoyed it very much so, but it's sort of like once you've seen one of these things, you've seen 1,000 of them, and you did have to look at hundreds of patents every year. Granted. So I went to night law school while I was here and worked probably the 3 hardest years of my life, for working full time and going to school in the area. Graduated and got a summer associateship and then a job at a firm named Finnegan Henderson here in DC. Really enjoyed my time in law school, really enjoyed my time at the firm. Was at the firm for about 3 years. And then a client of mine who liked my work in this new area of administrative challenges brought me on as sort of the first working attorney. That was about 10 years ago. And every year since then, we've grown and I've hired. And it's been an organic pathway to growth where I've taken on more and more responsibility and now get to be sort of a jack of all trades and do some sales and do work on the board and work with the business side, budgeting, management, legal, you name it. It's been a really interesting ride.
It's funny. We have similar backgrounds. So you went to Tulane and got your BS in biomedical engineering, as you mentioned, and then on the USC for journalism, and then American for your JD. I had a technical background as well. I went to Holy Cross and was pre-med psychology. Got the kind of the broad technical background to qualify to sit for the patent exam. Did that as a second year after this, my summer after a second year in law school, and became a patent agent and had dreams of becoming a patent attorney, and just things went in a different direction. But similarly, had a technical background. Was never good in the languages topics. Verbal was always my weak skill set on some of the standardized tests. So I've become more of a well-rounded individual, but certainly started on the math and science side of things. So you started. Why don't we tell us a little bit about your role, or what you were spending most of your time doing as outside counsel at Finnegan Henderson at the start of your career?
Sure. So in 2011, there was this new bill called the American Invents Act that changed the landscape of patenting in the United States. It allowed parties to file administrative challenges while litigation was going on, and basically get the office to take a second look at patents to see if they made a mistake. And it turns out that an office that grants 400,000 patents a year makes a lot of mistakes. So this was a brand new area of practice. I was one of the, as a summer associate, I drafted the fifth ever one of these. I was up all night on a Saturday night till 5 a.m. trying to get this filing out because some partner just said, run with it, go do your thing. And then I did, and it was successful. And so I kind of just was off to the races with this bright, shiny object. It was a lot of fun, and became a little bit of a mini expert. And then my company now did a lot of those filings. And so it made sense for me to make the leap. It was very early in my career, but I was very lucky and took a risk, and it paid off. And the company has been very good to me, and it's been a fascinating place to be.
Tell us a little about Unified Patents. What's the business that you conduct?
Sure. So Unified is a membership organization. We've got about 300 members. A number of other membership organizations are our members across industries. So basically the entire cable industry, the entire crypto industry, a lot of the car and banking industries, a lot of tech companies are our members. They're interested and concerned about the high cost of patent litigation, in particular a form of patent litigation where lawyers will buy up patents and then assert them and ask for less than the cost of defending them. So that's pejoratively called patent trolling. Other people call it non-practicing entity behavior, or NPEs for short. But it's estimated at a huge percentage of all litigation every year is this sort of file and settle, low-level fee litigation, kind of a Better Call Saul situation where it does not make financial sense for any one person to defend themselves because it costs less to just settle to go away, but then they turn themselves into a target because they have already settled with someone. They'll settle again the next time around. We kind of wear the white hats. We try to come in and use all available public means to file challenges and put out prior art and do what we can publicly as a third party to try to make sure that people can't profit off of patents that turn out to have been granted improvidently or that are bad patents. And because of that, I think our members love us. We've had a growing membership every year. It gets bigger and bigger. And it's been a really interesting place to sit in the middle of a lot of different industries who all share kind of similar concerns about a form of litigation that is oftentimes not dependent on the merits.
Yeah. So let's talk about patent trolling in a little more detail. So when did it really rise in popularity? What can that be attributed to? And then how has that kind of evolved over time?
Sure. So like 30 years ago, companies would sue each other. Maybe even 20 years ago, they'd sue each other and they'd get into these giant patent wars where I have 100 patents and you've got 200 patents and we'll sue each other on all these patents. And it was sort of a bloodbath, and everybody would lose because it cost so much money. And then eventually they'd strike a licensing deal that, this is a bad example, but Pepsi would pay Coke a little bit of money because Pepsi had more patents in their portfolio or whatever. And then they would move on, right? And it was really bad for business and disruptive for business. And then at some point, some smart attorney figured out that you could create holding companies, an LLC that had limited liability, and assign all of your patents to that entity and run all the litigations out of that shell company and pass through any revenue that you got. And if you failed, you could just declare bankruptcy of that organization and there would be limited liability for the fees. So they really are shell companies. They're called holding companies or shell companies. Companies would do this when they sued each other. And then eventually, because there was so much of this activity happening, some of them were turned into actual sales where it was just an enterprising attorney who said, why don't you sell all your patents to me? I will then be able to keep all the proceeds, but you pay me $300,000 or whatever it is for your portfolio. I'll then go out and try to get $500,000 or $800,000 out of it to make a profit. And so that started little by little to develop steam. And now the vast majority of all patent litigation in the United States is brought through these proxies. Some of them are just lawyers running the organizations that have had patents sold to them. Some of them are related to other companies that are hiding behind the shell. And others are now funded by patent, they call them litigation financiers, by people that literally just fund litigations to make a
Yeah.
profit.
So
Go ahead.
are the entities purchasing, so the patent trolls
Yeah.
are these entities, these shell companies that are either created by and affiliated with another company, or are just, you can have, it sounds like you, if the troll wanted to acquire a patent portfolio, pay 200,000 for it and try to make 300,000 or more off of the litigation, that's kind of, that's where the practice originated, and is just kind of taken steam from there, particularly as litigation finance has become important. Does that sound accurate?
Yeah, that's right. What's interesting about this space is that it takes a little bit of work and time, but we've done some studies that show the margins are actually 20 to 1, where if you have a successful campaign, you might buy it for 100,000, the patents for $100,000, and expect to make $2 or $3 million over the course of the campaign, because you're suing a lot of companies. You're not just suing one company or two companies. You're suing all of the cable companies, or you're suing all of the car companies, or all of the camera companies out there. And so that means that it represents thousands of litigations filed every year. It's about 3,000 or 4,000 patents litigations filed every year. Far more than any other area of federal law. A lot of money changes hands, and it has kind of turned into a self-fulfilling prophecy where patents are sought for, and then people know they can go sell them off. They sell them off, and then some lawyers know they can make money off of that organization. So now those organizations have funding, and then it just sort of continues.
Interesting.
It's sort of a vicious cycle.
How are the patents that go into the portfolio that is purchased by the patent troll, how are they selected? I mean, I'm thinking, if if a company who owns those patents and sells them to a patent troll, what, don't they need those patents? In other words, of their patent portfolio of 500, do they choose a subset of 200? And if so, what's that selection process
Well,
look
it's going to
like?
be different from company to company. Some of them are bankrupt companies that just all their patents get sold off in bankruptcy, and that happens a fair bit, like with Nortel, you may remember, or BlackBerry. Those portfolios have all sold off to private equity groups, or sold off to NPE lawyer groups.
Got it.
Also, patents are kind of Americans think of patents as being protective when they don't know that much about them, like it's a shield, but patents are really just a sword. Patents are useful to sue someone else to try to obtain damages, or to try to stop them from doing something else, but they're far more useful to assert proactively than they are to defend yourself. And big market leaders don't really need patents to assert against anyone else. This is true for across the board. Smaller groups don't really need patents to assert. They need to compete in the marketplace, right? So unless they plan to just maximize a bunch of revenue from their patents, it turns out once they have them on their books, they have to pay fees to keep them up. They have to monitor them, and it ends up being a cost center. So some people will get patents and then sell them off just to try to make money down the line. Some people will lose them in bankruptcy, or they'll borrow money from someone who will then take them as collateral.
Interesting.
Not a lot of patents transact. I mean, a lot of patents stay with their original patent owner, but a fair number do, to the point where there are now a series of brokers and a series of websites and organizations that all they do is sell patents every year. Right.
So it sounds like the patent industry has evolved in a direction that probably wasn't intended when the idea of a patent was first generated. Is there anything being done about this? I mean, is there litigation that is being introduced to try to curtail some of this perhaps nefarious activity, and try to get back to the core of what patents were designed to do?
I mean, there's always people that are interested in it and that are talking about it. So there's people that are interested in, if people are engaging in unethical behavior. There are people that are interested in trying to refer them to state or local bars. There are always reform efforts and counter reform efforts on the Hill. There is a lot of money in this.
Yeah.
So the flip side of this is that a lot of people are heavily invested in the current structure, and a lot of them would oppose, who have a lot of patents and make licensing revenues from those patents and what have you. This includes pharmaceutical companies who use patents to protect their key drugs, right? But it also includes licensing entities that do a lot of research but don't necessarily implement things, and so they make a lot of money off of their 5G networks or their Wi-Fi or their standards. And so the short answer to your question is that there's a lot of people that are invested in the system as it currently stands. So I don't foresee there being some sea change that gets rid of the ability to buy and sell patents. I think there's a lot of people that would oppose that, but there certainly are pluses and minuses to it.
Yeah, and it's easy to see some of the downsides of the current paradigm. What are some of the upsides of, you mentioned some of them, I think you probably just mentioned, but I mean, what advantages does this system of monetizing patents present to which parties?
Sure. Well, the argument is that inventors will seek a patent, small amount of money, get the patent, and then they're not in a position to be able to assert it themselves against much larger incumbents, right? So they're not going to be able to run out and sue a Fortune 500 company. But someone who's a professional who they've sold it off to might. They might be able to put it into a portfolio or assert it later because they figured it out as a science or what have you. So the idea, an argument goes that this is how you pay inventors back for their important assets. So creating a liquid market and a value of all patents that's inherent gives money back to original inventors. And it's a nice story, but the vast majority of patents in the United States go to incumbent companies, right? They go to companies that are already market leaders, or a lot of them now go to foreign companies because foreign companies can apply for US patents as well. So for instance, Huawei keeps getting more and more patents, or ZTE keeps getting more and more patents. It's not good or bad, it just is what it is. And so this idea that it's a incentive mechanism to allow non-incumbents to challenge incumbents has been around since the beginning of time. It doesn't really bear out much in the data. But it's certainly one argument for it. Another argument is just that making them liquid assets and making it more about the merits of the individual patents strips out bias, in theory, for or against incumbents.
Okay.
I'm not sure that actually ends up being true, but patents are sort of a strict liability crime in that you're supposed to look at the language of the patent, and if the product that you're doing infringes the patent, then that's the end of the story. There's infringement. The patent's valid and infringed, you should pay the person, regardless of who they are, regardless of, whether it makes sense. If you've got a cancer medicine and you paying could put you out of business, it's like the law doesn't care, right? The law wants you to move forward because you got the patent in the first place. And so in that regard, it's actually pretty attractive from a plaintiff attorney's perspective, because large damages awards, right? Because we're talking about large product launches and things like that. Strict liability, so you don't have to worry about things coming out of left field necessarily. And it is still a jury issue, and so you can get in front of a jury and tell this story, and the story is usually, I got this patent from the office, it's got a gold seal, look how great it is, look, my client, this small inventor, this LLC who doesn't have the money to even have an organization, is up against this Goliath, right?
Yeah.
And sometimes that's true. Sometimes they're funded by someone else, or sometimes it's not true. But it makes for a compelling story, and a lot of formerly successful plaintiffs attorneys in like slip and fall cases and other areas of the law have migrated to patent law because there are so many really high profile opportunities in this space.
Wow. And you mentioned data earlier. I mean, big data, even maybe artificial intelligence. How are you seeing some of these trends on a on a technical level, how are they contributing to patent trolling, litigation finance? You mentioned similar mechanics that drive those practices.
Sure. Well, they're allowing people to push things to scale. So there are
Yeah.
people already that apply for 10,000 patents a year, right? There are now companies that all they do is create patent applications for folks. So they say, we want 100 applications on the next 6G standard. Here's all the documents of the people talking about the new standard. And they put it into their AI machine, and then they spit out patents. There are probably 30 or 40 service companies in the IP space that claim to use AI tools to either get you more patents or cancel patents or assert patents. So just like any other industry, there's a lot of tools that are emerging. Whether they're effective or not is anyone's guess. And then there's a fear right now that people will seek and get patents on AI technology and then assert them against AI technologies that are making money. So OpenAI has been sued. Microsoft has been sued on patents that clearly pre-existed the GAI revolution, but that nonetheless the patent owners are claiming read on these new products. And so there's a fear that there's going to be a lot of litigation in AI moving forward. I think it started in copyright, and you've already seen there's like 35 or 36 suits this year based just on AI and copyright. But there's also going to be a fair bit now that are based in patents here and in Germany and overseas.
So the patentability, at least from what I recall from starting this way back in the day, patentability of software was kind of an interesting topic. How is AI patented? Talk a little bit about kind of this space of copyright versus patent.
Yeah, so there was a decision in 1999 called State Street Bank that sort of changed the way that people were looking at business method patents in particular. It was the early days of software, and so there was a question of whether you could apply for a patent on software. State Street Bank basically held that you could apply for like a method of doing business. They call them business methods, and that opened the door for patenting a lot in the 2000s on software methods or methods of use of software. And that led to there being just we went from granting 50,000 to 100,000 to then 300,000 or 400,000 patents a year. A lot of those patents are software patents or 5G patents or method of use patents for types of software. Eventually, the Supreme Court corrected the business method question and said business methods are not patentable. And they've also pulled back a little bit on this idea that you can patent an abstract idea. But it's fuzzy, and people still get patents all the time on just pure software, or they get patents on AI tools and transformers. And look, there probably are a lot of very legitimate foundational patents in that space. I know that Google has some very foundational patents in the transformer space when they were first coming up with some of the things that made generative AI possible in their translation tools years ago. But there are also a lot of people out there that are chasing these companies and trying to get patents on things that they think read on them. And that's where we are right now. We're seeing an increase in grants of patents in that space. I saw a report a few weeks ago that said that the biggest patent applicant in the generative AI space is a Chinese company, is Huawei, and there are other companies that are trying to sort of build up war chests in this area of patents that read on generative AI technologies. And I predict very soon there will be a lot of lawsuits of people trying to basically cash in when they see the market cap of Perplexity, and when they see the market cap of OpenAI, and they see the market cap of all Claude AI and all of the other subsidiaries that have been coming out. I think there will be a lot of severe litigation.
You provided an example of what within AI would get patented and how that patent could be enforced in practice.
Yeah. So say that again.
So what within AI can get patented. Can you provide an example of kind of what an AI patent would look like,
Yeah,
and how
yeah,
that would get enforced?
I got you. If I had the answer to that question, then I'd be making a lot more money, and I think I would be like a genius, because
What are we doing on this podcast? Let's get to work.
yeah, it's very confusing in the United States. It's very confusing where the contours of what is an abstract idea is or is not.
Okay.
And
Okay.
so in Europe, it's a little bit clearer if it's tied to an actual device. So if you say, I'm using a server and I'm using this chip in this very specific way to create queries or whatever, it'll probably survive this abstract idea text. And then if it is new, then you'll get a patent on it. But here in the United States, we don't have a very simple test. It's more like, is an abstract idea being applied? And it's a two-step test, and it's a little complicated. So the office puts out examples all the time, by the way, of what they think is or isn't complicated to try to help people. And then lawyers complain about them not being clear enough. But safe to say right now, there are ways to get patents on aspects of generative AI technology, like the way that they query the servers, certainly the chips themselves, certainly the very specific system on a chip uses where they've put up and set up the chips in such a way that this is easier and faster to recall or use. That's going to be covered. And then the sort of foundational transformer technology and some of the algorithms that they applied, if they're claimed in such a way that they're an application of that abstract idea, are generally patentable, and they have been patented by Google and others.
Got it. Interesting. So to kind of take it out in perspective a bit, and back to unified patents, your membership organization, and just kind of tie that back into, okay, what do you help your members do?
Right. So the main thing is everybody sees this vicious cycle where they pay for patents that they don't want to pay for less than the cost of litigation. And then next year they get asserted against again because the NP took that money and reinvested it and did it again. And so when we were founded, the idea was there needs to be an organization out there that can't be bought off. And so our founding principle is that we never pay anything. We either cancel patents or license the patents and basically get them out of the system. But we are here objectively to show people that some of the patents that are being asserted never should have been granted in the first place. I'm a former examiner. I made a lot of mistakes. My boss is a former examiner. He made a lot of mistakes when he was there. And we basically know that. Anybody that's worked at the office knows that they're humans and they're fallible. And Congress knows that. Congress created a bunch of mechanisms whereby you can go back and check the validity of patents. Now, the people that are asserting know that as well, which is why they ask for such little money. Right? It seems little, but to a small business, $50,000 is a lot of money. And I'll give you an example. We have a small member called CD Universe, which is a guy that sells CDs out of his home in Florida on a website. It's just used CDs. He doesn't make $10,000 a year, right? It's just something he does for fun. He got a letter and was sued by an NPE, by a troll that called Shipping in Transit, that said, you use FedEx shipping. We have all these patents on school bus tracking technology, and we think it reads on your FedEx widget. So pay us $20,000. And this guy did not have $20,000 to give them. And he called in tears. And that's the type of thing that we really try to get at, is people that are holding up businesses across the board. And then when someone actually does take a look at the patent or has the money to spend on a lawyer, it turns out the patent never should have been granted in the first place.
So is a small business owner a member of your organization, and Unified Patents would essentially try to go invalidate the patent that is trying to be enforced against your member?
That's right. We're independent, so we get to decide what we're going to work on, and we basically go the distance. So if some member settles or some member wants us to stop, they can't tell us to stop. We just keep going and cancel the patent, right? And that's how it's worked from the beginning. So we make our own independent judgment calls on what to go after. There are, like I said, 4,000 suits a year and maybe 10,000 unique patents asserted every year. That's a lot of money, and no one can do all of that. We only do a very small subset of that, but we do our best to try to wear the white hats and find patents that never should have been asserted, and make sure that they can't be the basis of unfair settlements.
Interesting. So talk about your time starting at Unified Patents. Let's kind of go through your progression with the company.
Sure. So when I was first here, I was managing all of the in-house legal work and outside counsel. So that's kind of the typical thing that you would do as a litigation counsel or as a prosecution counsel at a IP services firm. I was pretty green at it, and I wanted to do a lot of the work myself. But every year we were able to hire a little bit, and I was able to get a little bit further away from the work. And I think this is actually the story of every general counsel, is one of having done the work very well, and then the Peter principle is like getting promoted until you're not good at what you do, right? You end up starting to manage a little bit and sharing with another person, and then you share with the team, and then you manage a few people, and then you manage a big team, and then you manage a lieutenant who manages a big team, and then, and so that process has happened very quickly over the course of 10 years, but I've been lucky enough to like see every step of it. I didn't just get plugged in from outside, from a firm to go straight to be an AGC, or to go straight to be a manager, or straight to be a chief of staff or something.
Yeah.
And it's interesting because I talked to a lot of other GCs and AGCs and chiefs of staff who are lawyers. A lot of people, this is their vector into the board, was the fact that they got a law degree and were very good at it. And very quickly, you sort of stop doing legal work and you start doing management and sales. And whether that's internal sales because you're talking to the board and communicating things up the chain, or whether that's managing your growing team and managing your budgets with your outside counsel, you very quickly don't end up being able to do a lot of the work unless you're totally crazy and you're working nights and weekends and maintaining a few cases for yourself just to feel like you're still in it. I frankly think that does a disservice to your team when you do that, because you're sort of forcing yourself on them when obviously your time is better spent doing something else.
Interesting. So the type of work, so you've gotten out of the day-to-day, or at least your day-to-day is not as much in the business, more on the business, or in a variety of ways. When it was back when you started out and you were more in the business, what did your day-to-day look like?
It looked a lot like being outside counsel, to be honest.
Yeah.
I would come into the office, I would do all of my invalidity work. I would have calls internally to sort of manage the docket. The cool thing was that I suddenly got to make a bunch of decisions. And outside counsel, you just do what people tell you. When you come inside, suddenly you're the one making the decisions. And so that's the new shiny thing for you. And I've always loved games. I've always loved strategic thinking. I think that's the most interesting part of any job. People say, "Oh, I hate office politics." And it's like that just means that you're not good at thinking strategically, because like life is strategy. You're always trying to think about how you get what you want to get done accomplished, whether you do it nicely or meanly or whatever. It's still all about having goals and getting them. And so I found that like early on that mindset helped me a lot, right? Like just into every challenge and thinking like, okay, we get to make the decisions. I need to lobby internally for what I think we need to do because I think this is right. I need to make the case internally. So I was able to like lobby internally and work on how to convince people internally. Also at the same time was in a position suddenly of managing outside counsel of people that were either peers or superiors of mine. And so that was a learning curve. I think the first year out, when you're outside counsel and then you come in, you suddenly see a completely different side of firms because firms are selling to you. So suddenly people that wouldn't give you the time of the day are trying to take you out to lunch all the time and trying to get you to give them work. And you start to realize who's good and who's shallow and who's charming, but who's bad at the work. And you suddenly start to understand people's reputations and why they're deserved.
Yeah.
And you also learn how to negotiate a budget, and you learn how to be pretty strict with outside counsel, even your friends. And that was very interesting early on. And then as that got to be rote, and as that got to be pretty, we're doing a budget again, here it is, or we're hiring again, here it is, whatever. Every year there's like been a new challenge or something new to grow to, which has been really interesting. Last few years been a lot more involved in direct member-to-member communications. I've always been giving speeches and on calls, but now it's much more of member acquisition. So it's out there talking to new members. It's being on the road, writing and speaking, managing the team and also going to the board meetings and making sure that everything's handled. But at the same time, really just doing a little bit of everything, or a lot of everything, as the case may be. And
how large was Unified Patents when do you remember how large the organization was when you joined?
3 or 4 people.
Okay.
Very small. I think I was the first official office, or maybe the second official office. We worked out of a WeWork for a while, and now we have 25 people plus a whole army of consultants and contract people and things like that.
Yeah.
So still pretty
Yeah.
small for what
Yeah.
we do and for our market cap and everything. But I don't know if that's the right terminology, but definitely dramatically different over 10 years to grow from 3 to 25, and we're growing every year. And so it's been really fun to, and I'm very blessed that it happened organically. Again, I know people that have never managed, who suddenly have to manage 5 people and don't know where to start. And sometimes you just get so overwhelmed, you don't do a very good job. Whereas if you start small and you do 1 year, and 2 the next year, and 3 the next year, and 4 the next year, it just feels like being a duck in water, you know?
Yeah. And I mean, as Ivory grows, it's been a similar experience over the last few years, in that it was just me a few years ago, and then it was me and one other part-time person, then it was me and 2 other part-time people, then me and 1 full-time, 2 part-time people. I mean, it's, as the role has evolved, you have to do everything. I mean, I was sending signature requests when I started, Ivory Law Group. And I think it does make you a better manager when you've done it and you've gone through that progression, because you can speak the language of the folks that are boots on the ground, so to speak. And because you were boots on the ground not long ago, or it's been an interesting progression that way.
I bet it can be frustrating for a junior, because you sort of know where the bodies are buried, and so you're like, I know that won't take 2 days.
That's also true. That is also true. How large is the legal function, I guess, talk about the legal department at Unified Patents? Are you solo, or do you have others working with you?
No, yeah, I manage a team of anywhere from 8 to 12, depending on the year, of direct reports, or I guess now indirect, because I have someone who's helping manage the whole team. But that is the single biggest function, is the legal function, right? And so it's interesting to be a GC in a company that is basically mostly, or at least partially, a legal services company, because you end up being involved in a lot of the decision making, and you end up being involved in a lot of the management, even of other things, because they end up serving or being a subsidiary of it. That's been pretty interesting. I've been involved in all the hires and everything from beginning to end, and I think I've learned a lot about attorney hiring from that, and interviewing. And it's definitely
what have you learned, out of curiosity?
Well, one thing I'm not sure I'm supposed to say, and I got to find an artful way to say it, is that from the beginning, it's really important to me, as a company that didn't have a lot of guardrails on it, to emphasize, especially in patents, to emphasize diversity above all else. And like, we would go out of our way to try to find candidates and ask candidates to come in and everything like that. We have hired and gone through maybe 15 people now, and of the men versus women that I've hired, or of the diverse attorneys and non-diverse attorneys that I've hired, it's a small sample size, and it'll change. But I have to say that, like, almost all of the people that I've hired that are diverse or women are just like lights out, punching out of their weight class, really good, super motivated, great hires. And we have great hires that are not in that category as well. They're all great hires, right? But really kind of just going above and beyond. And I had an old hand who was an in-house counsel at Johnson & Johnson years ago, who said when he was in private practice, when there were like almost no firms that would even hire women, he would hire nothing but women, because he found that they were working twice as hard, and they were running circles around people, and they would come to these depositions and just dance all over the bodies of these attorneys on the other side. And he was like, trust me on this. This was years ago. He's like, trust me on this. Like, you'll never regret it. And
You're
obviously,
preaching to the choir here. I mean, this is
uh,
at Ivory we've had, I mean, 90% women on the team here, and they've been fantastic, very hardworking. I mean, obviously, vast generalizations here that we need to be
of course.
cognizant of. But my experience, they've been my colleagues have been incredibly hardworking, especially the women. They really have a good drive, and they're very capable. Wouldn't expect anything else, but it's interesting to see just that dynamic. I mean, I've always gone out. My hiring technique has been, let's go find the best person, and that
Yeah.
person has oftentimes been a woman.
Yeah, same here. So whenever people have these complaints about not being able to find the right people or not being able to find enough candidates or whatever, I'm sort of like, I don't know, man. I don't know.
Yeah. And so what does your internal legal department do, and what do you use outside counsel for?
So so there's a lot of different ways to answer that, but the short way is to say that is leverage, right? Like most legal groups, I'll just use patent prosecution as an example. It's not something we do, but let's say you're Johnson and Johnson and you need to do 100 different patent applications for your various business groups.
Yeah.
You can choose to send all of that work to outside counsel, and it is a fixed cost, or you can choose to bring people in-house. And then there's some line where it's like 75% of the work in-house is the most efficient because there's always going to be overflow and you don't want people to be idle, and it changes every year. And it's very similar with us. We have a certain number of filings and certain number of legal functions that we need to accomplish every year. If we were to send it all out, it might cost X. If we were to send it all in, it might cost Y plus salary, but then there'd be overflow. And we would, you don't want to get to 100% of the work. And I've found that a good rule of thumb for in-out, and just because of how subjective and fluid it is from year to year in most businesses, is like 75%. Like if you can do 75% of the work you're capable of doing in-house, that you don't need special expertise or like an M&A lawyer or something like that. If you can do that work and send the overflow to your trusted outside counsel, they will always be there, right? They know that they're a services firm and it's fungible, and you'll find good people there too. But it's always more expensive to send the work out and have someone else do it.
That's interesting. And how have you seen outside counsel in your space evolve, or really how's the practice internally as well? How is your internal practice and the practice of your outside counsel partners, how has that evolved over time?
I think they're two separate questions. So outside counsel practice is interesting because it's my primary point of entry is fees and how they charge you and how flexible they are on alternative fee arrangements. And you'll hear a lot of GCs talk about this, particularly probably in the patent space, because they might be a little bit slower to abandon the hourly rate. I understand why the hourly rate makes sense from a profits per partner standpoint and from a partnership standpoint. And I understand that it's a long metric that people are used to, but the vast majority of clients want like this thing filed or this defense to be like a set number over a certain number of months. And so I've seen more and more partners get more and more comfortable with offering either fee caps or set rates or price per, like, so a price for filing is X, and they will set a budget that's not really a budget. It's like, this is what we're going to pay you. And one interesting thing that's happened probably over the last 10 years is people will tend to agree to these things more and more. But a lot of them, a lot of lawyers so far haven't really been so professional about keeping to their original promises. Like it's more of a budget conversation where they think this is what it's going to be, and then the work changes, and that hurts their realization. And so there's a lot of coming back and begging for more, begging for a change or what have you. And that's awful from an in-house perspective, because you don't want to tell your counsel that you work with all the time no, and you want to be nice, but you have your own budget perspective. And so it's like, if it had been in the original budget, then it wouldn't be a problem to pay you more. But I have goals, and I can't, go and have these huge swings in months that I didn't expect. We're not run by a spreadsheet, and we're not robots, but we do want to have a regular clip to things. And so when unexpected things happen and people are over promising and under delivering in terms of what the costs are going to be, it can be a big problem.
Yeah. So over the last 10 years, you've grown into the general counsel position. What words of advice do you have for other GCs in managing the team? What have you found to work well?
I mean, people say this all the time. The first thing is just to hire good people, right? And then they'll make you look good because you just don't have to do that much. But I favor a light touch, right? I favor making sure that you hire competent people and pay them well. And then when you manage them like colleagues and not like lackeys. And hopefully people that can manage their own docket and you're not looking over their shoulder. I've never met anybody that really enjoys working and living in a fishbowl. And I think attorneys are probably even more independent minded than others. And so managing a team of attorneys is kind of like managing a team of cats that all want to do their own thing and they're all very good at what they do. But, you know, you're not necessarily supposed to just sit on top of them and tell them what to do. You're just give them goals and let them figure out how they want to do it. And I think that being very flexible in terms of when they're older in particular, I think flexible in terms of hours and face time and just granting your employees the respect that they deserve, that they're adults and that they can figure it all out is great. And it makes for a very happy and well-functioning team. And I also think fostering a positive environment where you're sort of congratulating each other when you get a filing done and you enjoy each other's time without overdoing it is really important. And if you do have a sort of toxic high earner or someone in there and you can't get rid of them, at least cabining them off and protecting everybody else from that and being concerned about morale, I think is very important. And also being very upfront with them about where the business is and what's expected of them. And I don't know. I think people just really respect when you level with them.
Yeah. So, Jonathan, you've got some Michigan Wolverine logos behind you. What's the connection to Michigan?
So I grew up in Ann Arbor, and I went to my first game with my dad in '94. It was that, I think, '94, '96, that Cordell Stewart Hail Mary to the back of the end zone.
Sure, yeah.
And I was sort of hooked from there on. And I didn't go to, my dad went to Tulane and my mom went to Michigan. So I ended up going to Tulane, but still go to at least one, if not two Michigan games a year. And it's in my blood. And this is actually, my best friend in high school's dad was the general contractor on the stadium when they rebuilt it. And he stole this from the stadium site. So this is the original, they were going to throw it away, the original section of my dad's section. That's
really?
Best present I'll ever get my entire life.
Yeah, I'd say. That's cool. Very cool.
Very, very cool. Very, very special present.
Well, Jonathan, we wrap up these episodes with trying to give a piece of advice to a junior attorney that is either in your shoes or would want to aspire to be in your shoes today. What would you have told yourself 10, 15 years ago when you're just getting started?
Ego doesn't matter, that it's not about you, even though it feels like it's about you. And the people that really are like the best CEOs or the best whatevers are the ones that like never talk about themselves and make it all about the business and every your grades don't matter and where you went to school don't matter. What matters is perseverance and like getting back up every time you fail and not the first time and the 10th time you try something, you're bad at it, right? So just keeping on. Yeah. And then I think not enough people recognize that it's not a game, but that there's a meta to everything. You can't just show up, do good work, and hope to be rewarded. You can. I mean, that's you should be rewarded, and if the universe is working correctly, that's right. But you can also help yourself by having your eyes open and knowing what's going on around you and being honest with yourself and making sure that you take opportunities when they come your way. I think that's very important.
That's great. Well, thank you for taking the time to be with us. Wish you all the best and look forward to keeping in touch.
Thanks. You too, man. Happy to talk. Yeah.
Thank you.